welcome to December, everybody. Can't believe we're saying that already. This is the last HR Coffee Break briefing of this year. Suddenly discovered earlier that I'd actually been doing this for just over 2 years now, which I somewhat can't believe that I've managed to talk about that much stuff. But actually, part of today's chat really is somewhat based on that. Whatever. Bit of a look back over what's happened in the last year, a little bit of a look at what's coming forward, because it has been one heck of a year for us, I think. Admittedly, we seem to have been saying that a lot since about 2019, but in terms of actual legal and legislative changes, 2025, 2026 is probably going to end up being quite a significant one for us. Today's topic, therefore, as I say, looking back, looking ahead, what's happened. We'll talk through some elements of the Employment Rights Bill, some stuff that's going to be coming up next year. I'll dot it in with some interesting cases that I found over the last year or so. And today's session, slightly more relaxed, I think, because it's the December one, because it's the end of the year. I'm not going to go into too much technical detail, so please do feel free to chip in, make use of the Q&A, make use of the chat function as we go for your comments and anything you might want to add, and any questions you might have as we go through as well. I did say that I think in the marketing content that Justine would be joining me today. Unfortunately, she's not available, so you haven't just got me, I'm afraid. You put up with it being mostly just me for the last 2 years, so I think we can manage one more. I'm also not going to record the session today just because it is a bit more relaxed. We're not going to be covering anything that I feel the need to stick all over the internet. So do, again, feel free to chip in perhaps more freely than you would ordinarily if you're happy to do so. So, looking back, looking ahead, before we come on to that, I think probably the big place to start, I can't really ignore the elephant in the room. Unless anybody has been living under a rock for the last week, this title page should not come as a surprise to you whatsoever. Day one, unfair dismissal, the flagship Labour employment rights policy has been U-turned on, and we are now looking at a 6-month service requirement period instead. It's not often you'll get to hear one of us say this, but there is stuff that we have said on these previous webinars, therefore, that is now wrong and you can ignore. It's quite nice being able to say that for a change. I think when I've mentioned this previously, we talked about the possibility for the Labour government with such a large majority to force through its legislative programme in the way it wanted to do so. And I think we'd all worked on the assumption, that was going to be for day one rights because it was such a headline policy. That, obviously, as we've seen in the news in the last few days, is now not the case. And because of the contention from the House of Lords, because of the contention from employer representative bodies, this has now been completely U-turned on. So please ignore almost everything that we had said previously at any session whatsoever on day one unfair dismissal rights. So what did actually happen last week? Well, because of this negotiation, I suppose, of trying to get the legislation through without having to rely on the constitutional sledgehammer, I suppose, of pushing it through, we have got this compromise position where the day one plan does appear to have been completely abandoned now. What we have in place is the current 2-year qualifying period for an ordinary unfair dismissal claim is going to be reduced to 6 months. And this is exactly the amendment that the House of Lords had kept pushing back to the Commons, basically saying day one unfair dismissal rights are unworkable for almost every employer, ACAS, the tribunal system being overwhelmed. And so this is where we've ended up with sort of exactly what they were proposing. Now, of course, what this means is a lot of what we were saying previously, in a sense, is still correct, of course. It won't be a 2-year qualifying period. Those short service dismissals for up to 2 years will no longer be able to be assumed to be safe. But we do have this 6-month period where you're still going to be able to do that. And I think it's fair to say the vast majority of short service dismissals do happen in those first few months. We tend to realise very quickly that somebody's not perhaps the right fit for our workplace. This does mean that we will probably not see that initial period of employment, that 6 or 9 week so-called statutory probation period. I think we can safely assume that's going to go. It's frankly redundant if you've got a 6-month qualifying period anyway. There has also been some indication that there might be a change to the awards regime for unfair dismissal claims, whether that's amending the statutory caps or looking at the way in which unfair dismissal is awarded more generally. At the moment, we know, of course, we've got that 52-week, in effect, a year's salary cap on an unfair dismissal claim, or whatever the overall statutory cap is as amended on an annual basis. And there may be some change to this. Not least of all, because somebody with 6-7 months service, there is a question as to exactly, I suppose, what they should be claiming and in what circumstances you could say that somebody who's lost their job after 7 months is entitled to a year's pay, potentially. So the impact of this change on the implementation of I was going to say day one rights then, of the change to unfair dismissal rights. Recruitment was one of the biggest areas of concern here. I think everybody had been talking about needing to really formalise and get ahead of recruitment processes to make sure that somebody with a day one unfair dismissal right was actually the correct fit. Nobody wanted to go through even a light touch process in those first 6 or 9 months to get rid of somebody who just simply did not work within the organisation. I think we can breathe out a little bit there now if this is a 6-month period where you are still safe to do what is in effect a no reason dismissal, providing of course it's not automatically unfair or discriminatory, then I think we can have a little bit of a breather around recruitment processes and feel a little bit safer moving forward, knowing that option for a short service dismissal is still available to us. Next step, I suppose, in theory, the entire idea of this change now, and it's something that's been hinted already in the last few days. And I'm saying this because I've only really just seen it this morning. In principle, this could be rolled out much more quickly than the original intention. The change to day one rights was going to be 2027. It is possible now that because of how this change could be implemented, it could be a lot quicker. All it is a minor amendment to the law that simply changes the words 2 years in that qualifying period definition to 6 months. It's not going to require any change to introduce the initial period of employment, the statutory probation period. And in theory, because of that, there's an argument there's less work for us to do as employers in terms of implementing and rolling this out. That's not entirely clear yet. That is not set out in black and white that it will definitely come earlier. But there is scope for it to do so because the actual legislative change that introduces it is so much easier. Whether that will happen or not, I don't know. We will keep people posted as best we can as to when we see the regulations or when we see the amendment to the Employment Rights Bill itself that will actually allow for this to be introduced. You may have also seen that as of the 1st of this month, the ACAS early conciliation period has extended to 12 weeks. I am not going to be cynical at all and suggest that the government was already preparing for some kind of change to how unfair dismissal was going to work compared to how they wanted to, but this seems very unusual timing. Whether it needed to be implemented now or not is a different question. That is now, as far as ACAS are concerned, being rolled out, and any early conciliation period which started this side of the 1st of December is being assumed to have a 12-week period rather than the 6 that currently exists. So I think in principle what we need to be mindful of moving forward for unfair dismissal claims, more people eligible to bring it, that is still true. Short service dismissals, certainly within 6 months, are no longer necessarily going to be safe. The ACAS period is longer, the limitation period is going to be longer, and of course I think we can safely assume that the Employment Tribunal and ACAS will be busier in the future. So good luck to the tribunal system. I think probably the one benefit for us is claims could get so lost in the system that it takes so much longer to deal with them than an individual employee actually considers to be worth it. The only things I would suggest that still remain from when we were talking before, do tighten up your probation period processes. Make sure that initial review is happening at 3 months, and make sure that if there is going to be an extension or a final review of that, that it happens before the 6-month mark. You want it probably about halfway through month 5, just to make sure that you don't accidentally roll an employee into having unfair dismissal rights as and when they reach that 6-month period. And that's pretty much all I'm going to say on that at the moment. Like I say, a lot of what we said previously no longer relevant. Some changes moving forward, some of what we suggested still important, but in a slightly different way. Assuming there's no questions, comments, queries, or anything on unfair dismissal rights, I will move on. But obviously, please do feel free to pop things in the chat Q&A as we go. I'll pick up on questions either towards the end or as and when I see them. So let's talk about the case law. Let's break up some of the sort of more boring procedural stuff and talk about something interesting that's actually happened in the last year or so. Let's work out how many people are actually paying attention at the moment. Excellent. Yeah, a few people have done exactly what I was expecting you to do. So yeah, you've all done either a thumbs up or some kind of hands up response there. And what you mean by that, of course, is, yes, Chris, I agree. I'm listening to exactly what you're saying and haven't just checked back at the screen because you prompted me to. So I think that's fairly clear what you're all saying there. Yes, Chris, I agree with you. Hello, I'm still here. I'm in agreement. So when is an agreement not an agreement? Case law around this one it's actually quite a fun and slightly technical case. So we're talking about training reimbursement costs. Now, most of you, certainly if you've taken advice from us, will do this by way of a completely separate written agreement between the two parties, the employer and the employee, which is signed, makes it clear exactly what somebody is going to be reimbursed on or will be reimbursing, what the training program is, and the situation in which it is potentially repayable by the employee. The organisation in this case had done things slightly differently and probably not in a way that I would have recommended. They'd sent out a WhatsApp message on the team WhatsApp group that basically said, here is a training opportunity, we'd like to put you all on it, we're paying for it. If you leave us before the end of that training course, you will be repaying the costs and they'll be recoverable from your wages, from your notice pay, whatever the case may be. Within the same message, basically the last line of that message was, if you're happy with this, if you agree, please give a thumbs up response to this and we'll proceed as if you're happy to do so. And the claimant did so. She gave a thumbs up to that. Now, on the face of it, that appears to be contractual agreement. Here is an offer we are making to you. We'll put you through this training course. We will pay for it. The flip side of that is if you leave, you've got to pay us back. Has there been agreement to that? Well, yes, most of us have just demonstrated that we think kind of that wave, thumbs up, whatever response does indicate agreement in some sense. Now, I know you weren't all contractually agreeing that you were listening to me. I will be suing you for breach of contract if you weren't. But I think in this case, most of us would say, well, yeah, it might not be perfect, but it looks like the employee saying, yes, I understand and I agree. So this then happened and she did leave. And ultimately the business did look to deduct training costs from her notice pay and any outstanding salary. Those of you who have not seen this as a case report already and may not have encountered it on LinkedIn or elsewhere where I came across it, any immediate thoughts, any comments, any views on how that might have played out? I've just noticed a Q&A where I got one exception to the thumbs up earlier where I did actually get a here written out properly. I'm wondering if that person was preempting me talking about this. Yeah, a couple of mixed views on this then, quite understandably. So how this played out in the Employment Tribunal ultimately is actually not necessarily how you would expect. The tribunal didn't necessarily look at this as a matter of contract law and is there a binding contractual agreement here. Actually, how the barrister played this out was what amounts to a lawful deduction. So the specific claim brought was an unlawful deduction of wages claim. So you can make deductions from wages. We know this, all of us do it. You can make deductions where they are permitted or required by law. PAYE deductions being the best example of that, obviously. The other situation where you can make a deduction from an individual employee's wages is where it's been agreed in writing that you can do so. And that was the word that the barrister really focused on here in representing the business. And turned weirdly to the Interpretation Act, somewhere most of us don't think to look. We're used to looking at the Employment Rights Act, the Employment Relations Act, the Equality Act. I don't think very many of us look at the Interpretation Act very often. We should, because it tells us what most of the words that we're using on a daily basis in all of the other legislation actually mean. And under the Interpretation Act, what in writing means is what's defined on the screen there. Typing, printing, for some reason, lithography, I don't know why, photography, and any other mode that represents or reproduces words in a visible form. And on that basis, the Employment Tribunal concluded that an emoji is not agreement in writing. So, useful takeaway from this. Firstly, there are some very specific areas of employment law that do require agreement to be in writing. This is the best example of that, and this is absolutely why we recommend separate written agreement with an actual signature, or at least with some kind of written confirmation that the employee is in agreement with those deductions being made. It's easier from both a contract law point of view and apparently from an employment rights point of view as well. I suppose the other thing to take away from this is that sort of reliance in the modern world on those representations of what we think mean agreement to things. An emoji response in exactly the same way many of you did, of course, with the hand raise or the thumbs up sign, doesn't necessarily indicate what we mean it does, and we probably shouldn't take it to. So there's interesting case number one. Be very, very careful when making deductions, because even if there's contractual agreement, they might not necessarily be lawful if they aren't in writing. And always make sure that if you are doing training agreements, that it is set out clearly not only what the terms of repayment are, what is being incurred cost-wise, the terms in which it can be repaid and the situations in which it becomes repayable, but also very clearly that you do have the lawful definition of in writing appropriately satisfied. Question there about contracts of employment that are sent via some kind of platform and accepted by the employee. I suppose your question is going to be, is there a typed, printed, lithographical or photographical indication that there is some kind of agreement to that? I think I would probably still, in principle, prefer to see some kind of e-signature on that, if that's available under the platform that you're using. I think, again, accepting it under an employment contract would probably give you the contractually binding entitlement to do it and to recoup the money through the civil courts, for example. You've satisfied the definition of a contract, offer acceptance. Whether or not that would meet the definition for you to be able to make the deductions from wages in order to avoid an unlawful deduction claim is, I think, very different and may well fall foul of this definition. Okay, any other thoughts, queries, questions on that one? Yeah, I thought it was quite an interesting case. Like I say, the number of us who use kind of emojis and similar to express how we're feeling on a day-to-day basis, and this kind of overlap with how it actually works within the law and our professional environment. So that, by the way, if anybody's interested in it, that's the case reference. It's Rothwell and Gray's in Medical Group. It was actually quite a long judgment. There was other stuff in there as well. This just happened to be one of the most interesting ones. Okay, so let's have a little think back to some of what we've seen in 2025, do a little bit more kind of boring law review now, and then I'll get back onto some interesting cases in a minute, don't worry. So, 2025, what have we actually seen happen? The big one, the Employment Rights Bill. Now, obviously, given what I was saying earlier, we know that that is still pending final form. It's still waiting to actually be signed off properly and get through our entire complicated legislative process that the House of Commons has to follow before ultimately getting royal assent. But we do know from everything that we've seen over the last year that we've got the proposed roadmap for implementation of all of that. Do look back on previous sessions which were recorded and are available online if you want to look back at that. Whether that roadmap is now still viable or not is obviously a different question. Some of the proposals under it were meant to come in this side of the Christmas break. There's a very good chance that this won't be the law this side of the Christmas break. And whether that roadmap changes over the course of the next year, 18 months, whether some of the things are pushed back, whether some, as I say, in relation perhaps to increased unfair dismissal rights are brought forward, so to speak, remains to be seen. And like I say, as always, we will endeavour to keep you updated of that whenever we know about it. Rolled up holiday, of course, in some circumstances became legal. It's always kind of been legal de facto, I suppose, but is now actually legal in certain situations. So irregular hours, seasonal workers, for example, rolled up holiday became permitted earlier this year. Those of you who are involved in large-scale redundancy situations, and trust me, this is the most boring thing that I put on one of these slides today, HR1 forms have just gone digital this month. The redundancy service has finally caught up with the rest of the world, and you can now complete these forms digitally. It's in a slightly different format and some of the information you have to provide, but yes, thank God, we can now fill one of these in without having to write it all out and send it off. Strictly speaking, October 2024, but as I said there, the enforcement and kind of the practical implementation of it, I suppose, all came in earlier this year. The Worker Protection Act introducing that preventative duty, which we've talked about at length. I'm not going to spend time today talking about preventative duties around sexual harassment or the all reasonable steps duty due to come in. But again, that is one to be particularly mindful of. We're waiting to see the raft of claims that will no doubt follow under this and exactly how they will work out. But again, watch this space over the next year as we ultimately get regulations as to what reasonable steps are going to look like, and no doubt start to get some of the more complicated cases which are being decided as to what the duty was before we're actually told what any reasonable steps would look like. The other big thing, of course, that came in this year, the Neonatal Care Act, as of the start of April of this year, giving extended rights to families and particularly parents who are going through a situation where they are involved in providing neonatal care, or they've got a child who is undergoing neonatal care. Again, it was about time something like that was introduced. The previous options had only really been around relatively unprotected, unpaid parental leave. And I think certainly a step in the right direction. And we know there's going to be steps moving forwards towards enhanced parental leave, bereavement leave rights, and various other things being changed as the Employment Rights Bill moves forward into the Employment Rights Act. And that to me is some of the big things that's happened over the last year or so. There may be others that people are interested in. There were certainly other changes, but those to me are probably the big few. And ultimately, of course, we are waiting, as I say, for the Employment Rights Bill to actually be finalised before we look at all of the big changes coming up next year. So let's have another bit of case law, just another either interesting or fun one that I found from this year. Harassment. I wanted to talk about harassment because, of course, sexual harassment, third-party harassment, all likely to become issues over the next couple of years increasingly as the law changes around those. So I thought this was actually quite a nice example of one. Again, some of you may have seen this case when it was reported. I think The Guardian picked it up, certainly. I can't remember what other news outlets did. So the claimant in this case brings a harassment claim among various others. There was a whistleblower protected disclosure claim. There was an indirect, a direct discrimination claim. There was a constructive unfair dismissal in there. But for these purposes, we're only interested in the harassment claim. And her protected characteristic was her age. She was the oldest member of staff in the workplace. I think if I remember rightly, she was in her mid-60s. I've got no idea why my screen has just gone black, but I'm going to carry on talking anyway. And the harassment claim was basically based on the idea that, so I'm going to have to work out what's going on with my screen. Apologies, everyone. Help if I could see my notes, really. This is why I'm not recording this one. Okay, there we go. Not sure what happened there. So she had raised a series of previous grievances about the workplace environment, and in particular, the amount of what she described as quite noisy, boisterous fun. Junior colleagues were having while she was working. She talked about it being a distraction, preventing them from working, that she saw or perceived them as wasting time, not being as productive as they should be. She talked about it giving her a headache in the workplace occasionally, and ultimately her claim was, the specific element of harassment, was that a senior member of staff had sort of condoned, permitted, allowed this to happen, and that was the unwanted conduct. In her claim specifically, I put 2 quotes there. She saw extreme time wasting and low productivity from what she called noisy and boisterous younger colleagues. Now, ignoring the fact that the allegations themselves are potentially acts of age discrimination in that she appears to be lumping all of her junior colleagues together as being noisy, boisterous, with low productivity and extreme time wasting. This is one of those interesting claims that really focuses on the perception of harassment and how harassment actually works. So just again, by some way of indicating, which again I won't contractually hold you to, anybody want to give me a quick thumbs up? Let's say thumbs up if you think there was actually a claim here that really got off the ground. I think they're the responses I want. I mean, there shouldn't be, should there? Let's look at this logically. You'd like to think there isn't. I mean, the point is, of course, this is a reported case, so regardless of the outcome, this did end up in the employment tribunal. So let's just have a quick look. Harassment. And this is, again, why it's important, because, of course, this will be the same kind of test that gets applied to third-party harassment and sexual harassment in the future. Unwanted conduct. I think she can probably establish that. She can say that the working environment in which she was in was unwanted. That's usually a fairly easy part of the test to establish. And then I think from there forwards, the entire claim falls apart a little bit. Connected to the protected characteristic. I can't see, and the tribunal certainly couldn't see, how any of what she was saying there was actually in any way connected to the protected characteristic of age. The guidance to the Equality Act gives some good examples of things that can be, and for example, they say that it can be connected to the protected characteristic of sex to routinely put things on a higher shelf so that women can't reach them because women are statistically shorter. That you can see some kind of vague connection to. In this case, there is no link whatsoever. They weren't being noisy because she was old. It wasn't particularly affecting her because she was older than them. And equally, you've also got to remember that she's got to establish exactly what that protected characteristic is. Is she talking about herself within an age range? Or is she saying specifically because I'm in my 60s, because I'm 66, because I'm over the age of 40? There's not a particularly clear link there, and I do think she failed to establish that on reading what I have of the judgment. Even if she had then been able to show that there was some link to the protected characteristic, we get to the final part of the test. In a harassment claim, that unwanted conduct has to have the purpose or effect, as required by the Equality Act, to create a hostile, intimidating, offensive environment for the recipients, or to violate their dignity. And again, I think she would probably have struggled on these grounds as well, least of all because what people forget about this is that it's not an entirely subjective test. The claimant doesn't just get to turn up and say, I found it offensive, therefore it was. The tribunal's got all of these three elements under section 26(4), which they have to look at. So, perception of the claimant, fine. It is obviously an important factor as to whether somebody themselves says they were offended, insulted, whatever the case may be. But the tribunal can also look at all the other circumstances of the case. So that is where you get some of those cases with maybe slightly surprising outcomes of language being used on a workshop floor, for example, is arguably considered more acceptable to more extreme levels than it might be in an office environment. And then see whether it's reasonable for the conduct to have that effect. If it's entirely unreasonable for a claimant to feel offended, insulted, whatever in the circumstances, there is not a harassment claim. And again, there's several quite famous cases of tribunals basically concluded that a claimant gave as good as they got. So it was a case of 6 of one, half a dozen of the other, and that therefore it wasn't reasonable for them to be offended by behaviour which they were engaging in reverse. And obviously that wasn't happening here. But I think even if she had made the connection to age, the difficulty here would be, does a noisy environment violate her dignity? No. Is it humiliating? No. Is it offensive? No, not really. She might not like it, but that's not the same. And I think she's struggling to meet that test as much as she is the fact that there was no obvious link to the protected characteristic in the first place. So, yeah, those of you who fed back, yes, that claim did ultimately fail. There was no harassment claim established there. And again, if you're interested in looking at some of the detail around that, it's the case of Ritchie and Croom Electrical Limited. There is some interesting analysis, by the way, particularly for those of you who might be concerned about sort of third party and sexual harassment in the future as to exactly how the harassment element works. So Last big area then, looking ahead to 2026 and some of those immediate changes that are going to kick in and all of us need to be concerned about fairly early on. The government's doing a lot of consultations because they promised to, and they've suddenly realised, and that means they probably should. So there's going to be consultations on most of the big legislative changes in one way or another. Some are ongoing, some are to follow. The couple that are looking likely to sort of start now and into the beginning of next year, consultations on changes to bereavement leave and how that should be implemented, and also on the enhanced dismissal protections which are being suggested for those who are pregnant or on maternity leave. There are talks about enhancing those to having a protected period when somebody returns from pregnancy or maternity leave, during which it may become even more difficult to terminate their employment. At the extreme end, it could well be basically you can't for X number of months, obviously barring sort of business winds down, or acts of gross misconduct, I hope would be excluded from that. Down the other end, it may well be some kind of change around this current protected period that we have in relation to redundancy during that time, and that's exactly the kind of things they're consulting on. Things which are actually going to change, well, assuming the Employment Rights Bill actually does become law and there's no change to the roadmap. Day one family-friendly rights, so this is going to affect paternity and unpaid family leave to no longer have that kind of service requirement period that currently exists. They're also going to iron out the weird quirk between when you can take paternity and shared parental leave, which just because of the way the legislation was worded meant they had to be taken in a certain order. And that's just going to be ironed out as well. Statutory sick pay reforms in April, probably the first one that will affect absolutely everybody. I appreciate not all of you will have people who are taking paternity and unpaid parental leave, but SSP almost certainly will affect every employer. The two big things there really, removal of the waiting period, so statutory sick pay will become payable from day one of sickness absence, and also removal of the lower earnings limit threshold, that is generally the rate at which people start paying national insurance. Basically, at the moment, statutory sick pay requires you to be at or above that lower earnings limit. That is intended to be taken away, meaning more people, more lower earners, are going to become entitled to statutory sick pay. Opportunity really, I think, to make sure that your systems are in place, ready to do those calculations, ready to undertake those assessments, but also from a practical point of view, use this as an opportunity to look at your sickness absence management processes, and in particular start to identify those periods of persistent short-term absence. The idea behind this change is ultimately to combat presenteeism, and for people who are genuinely ill to actually take a couple of days off, knowing that they'll at least get 80, 90, £100, whatever the case may be, equivalent for the week. On the other hand, it does also mean that somebody who may be more on the cusp as to whether they should take some time off, and my mind here particularly goes to the ones who maybe routinely have the Friday off before a sports fixture, or have the occasional Monday off following the long weekend. Do get your opportunity, take this as an opportunity really to drive into that and make sure that you are getting clear established reasons from employees as to why they are absent. Especially as sort of unfair dismissal rights change, if you're going to want to be able to get rid of somebody for short persistent absence, that's going to need to be documented, it's going to need to be fairly well record kept. Also starting next year, we're going to start to see some of the changes to trade union rules. The first two big things really are around balloting, and then steps towards the recognition process of trade unions. I haven't done a huge amount of this on these sessions yet. I talked about it in a little bit more detail than what about in-person events, mostly because I know most of our clients don't have recognised unions at the moment, so the balloting concern was less of an issue for them. That said, the entire purpose of the slow rollout of a lot of the trade union changes over the next 18 months or so is to increase recognition and ultimately to increase the involvement of trade unions, ideally voluntarily. If one of these sessions dedicated to the changes to trade unions and how that might look over the next 18 months would be useful, please let me know, and I will look at doing one early next year just to cover off some of the changes. It is complicated. I am very conscious that the vast majority of us won't have dealt with trade unions other than maybe having them there as a rep at a disciplinary hearing for quite a long time. Okay, and let's finish with the usual Scrooge stuff, because this is the December one. I haven't done a post about Christmas parties yet, because you've probably had hundreds of them from every HR and employment lawyer on the planet, so I thought I'd cover it off very, very briefly. Now, I'm not going to patronise you about Christmas parties and making sure that people don't get drunk at them, because I know A, they will anyway, and B, you all already know that. However, just a reminder, Christmas parties organised by, paid for, extended from, involving to some extent line management structures in any way, shape or form, do carry the risk of being an extension of the workplace. This means all of your vicarious liability duties continue to apply, and in particular this year that we've not had in the past really, although we were mindful of it last year, the preventative duty in relation to sexual harassment. The good news coming from all of this is that final point on the slide here. I don't know where these statistics come from, and I can only assume somebody actually sits and reads every tribunal judgment and does the numbers. But apparently there has been a significant decline over the last couple of years in the number of claim forms and cases being dealt with by the tribunal that actually cite or involve Christmas parties. So I can only assume from that one of two things. Either everybody has suddenly become exceptionally well behaved at their Christmas parties, or none of us can afford to be doing Christmas parties, and so it's just the case that there are fewer parties and therefore fewer incidents. That said, you know, I can't not do a session in December knowing Christmas party season is coming without mentioning these. Please, as much as I would love to take on and get all of the associated time, cost and summer holiday next year of defending a major sexual harassment claim from one of you, I'd much rather for your sakes it doesn't happen. So please do be very, very mindful when it comes to this time of year and what you're arranging, what your risk assessment looks like, and making sure staff are aware of some of the risks associated with Christmas parties. Which brings me on nicely to one piece of case law which is not about Christmas parties, but is vaguely connected to Secret Santa. Those of you who are paying attention to this, I've been told to be very careful about what I actually say on one of these sessions, even when they're not recorded in relation to this one. So I will let you immediately go and look up the case on this one, which is Cochrane and Neerock Limited at the top there. I've jokingly said it as homework. This is where I see on my screen that everybody's suddenly gone off this page because they're all Googling it. Ultimately, what we had here was a Secret Santa discussion which happened before the member of staff joins the workplace in the first place. It was taking place on I think it was a Teams group, it might have been a WhatsApp group, one or the other. And what was considered an inappropriate image as a potential gift was posted in that chat conversation. This employee, when he joined, was then later added to the chat and was able to scroll back and look at what had been posted. He initially, well, he resigned in response. There were a few other issues as well. He did try a constructive unfair dismissal claim and obviously realised very quickly that he did not have the requisite 2-year service to bring that claim. So added the fact that he had been exposed to this inappropriate image as an example of sexual harassment. I'm waiting for the first person to indicate that they found it. I don't know if there's a copy of the image available anywhere, by the way. There's a description in the case. Now, again, thinking back to what we were talking about with harassment earlier, this is capable of being sexual harassment. It is an inappropriate image of a sexual nature. You could argue it was unwanted. And does it have the effect of violating dignity or being humiliating or offensive? Yes, potentially. That said, we end up at the last part of the test in his case, and there's a couple of elements to consider here. Firstly, to a greater or lesser extent, there is an argument that this was self-inflicted. He didn't have to scroll back and start looking over old chat conversations from before he joined. And although that's not a perfect defence, it does start to fall into the argument. He went proactively looking back at previous conversations unnecessarily. Unfortunately for him, he was also possibly the worst claimant you could ever ask to have in terms of the evidence he was giving. And in particular, as I've said on the bottom there, he said in evidence that he originally saw this post, quotes, as a laugh. Is it therefore reasonable for him to say that he was offended, humiliated, or that it had violated his dignity? Almost certainly not. Now, this is another case where it wasn't successful. And obviously he wasn't able to establish it wasn't able to establish that there was actual sexual harassment in this case, and the claim was dismissed on this particular basis. But again, it gives us an example here. These harassment cases do make their way into tribunal. There was still a time cost element to this, which the employer had to go through. They still had to instruct representatives. They still had to turn up to a hearing. There is still a public judgment on this. I don't know if everybody can see the question thread, but it has just been posted as to exactly what was found there. So there is a direct reference. It's obviously point 1 when you find it. There was a particularly key example of his sexual harassment here. I'm sure all of you will eventually find it, if not now, then during the course of the session. But yeah, feel free to post it in the chat, which I think is more open if anybody is able to access that. I think I can only see the Q&A, everybody can see the chat. But yeah, so this claim ultimately unsuccessful, but it does show an example of where we need to be. Again, actually, particularly careful with group teams, WhatsApp style chats, and if they are an extension of the workplace or they are facilitated by the workplace in some way, then it is still possible for people to bring these claims in one way or another. And as I say, even if it's not successful, we still see the entire legal process having to be followed and the associated cost of doing so. So that, I think, is it from me today. I'll come to any questions in a moment. I appreciate people knowing that's the end, will probably want to jump off in a moment. I think most of us are probably starting back on Monday the 5th, certainly. I think we are, so I won't jump straight into this on Wednesday the 7th. I think that would be unfair. So next session, most likely to be the 14th. I haven't got a topic for it yet. I'm sure I'll come up with something in advance. Otherwise, for now, thank you everybody for joining these. Like I said at the start, it's incredible that we've got through 2 years of these so far, and you're still all turning up to listen to me talk rubbish. Please do continue to do so. I do hope you find them useful. I do hope you find them engaging. Otherwise, if I don't speak to you beforehand, please do have a great rest of your day, great rest of the month, and I look forward to seeing all of you in the new year after a much-deserved break for all of us. All the best, everybody. Thank you. And yeah, I'll address questions just as we go now at the moment. So SSP data from pay 1. If we've got someone taking repeated odd single days off for fatigue, how do we handle it and stop the pattern escalating now that each day is payable? You need to treat that as a sickness absence process. And ultimately what you need to be doing is sitting down with this individual and saying, look, we've got this pattern of absence, that can't continue. I think you need to be mindful that there's a potential disability in the background. If we're talking about fatigue, we need to know exactly what is causing it. But I think that conversation needs to start to be had quite formally, and this is about treating it as a persistent short-term absence issue. So I would be inclined to sit down with them next time it happens, look back and say, look, there's been 7, 8, 9, 10, whatever the case may be, instances of this over the last 6 months. It's an issue for us because, of course, we can't continue to have you out of the business for these periodic days as sick leave. Is there anything we need to be doing to address that? Is this something that you need us to support you with? And failing that, we need to look at taking some kind of action here, because either what you're saying is you can't work full time with us because it's causing a problem, or ultimately we need to address this as a disciplinary issue or stroke capability issue. It will depend a little bit on the specific circumstances. As we know, if they raise this as a potential disability issue, we'll need to handle it more carefully, more sensitively. It also depends on their length of service to an extent. Bear in mind as well, unfair dismissal and statutory sick pay, both generally only employees. So if this individual is a worker, it might be a very different conversation as well. So to say, very circumstance dependent. Anybody else? Anything you want to say, add, comment whatsoever? No? Right, if not, there's about a couple of dozen of you left on the call, so I will say thank you again there. Looking forward to seeing you all in the next year now if we don't speak before. Thank you very much, everybody.